world with support issues. That comes up. So let's just start with, what do I tell my new attorneys that come in that are working with me, how to know about the child, how to know about child support? So 2 things. I tell them to, number 1, read, read, and read. And what I mean by that, you can get 99% of the basic information regarding child support if you go ahead and you go online and you look up Article 4 of the New York State Child Support Standards Act, or New York State Domestic Relations Law 240. If you read that information, and I'm going to tell you, it's going to be like watching paint dry. It is very boring to read, but if you read that, you will get the basics of how child support is calculated, what is income, what type of discovery do you have to put forth as far as a petition, how to file a petition, the process of after you file a petition, how matters proceed. All right, so that's what you have to do for any new attorney or someone that's not an attorney that's interested in learning about child support. Just go online and look up Article 4 of the Family Court Act. Okay, and that is the child support issue. Now, the first thing we're going to talk about is, who pays child support? Now, everyone thinks it's based on custody, right? Well, it is. And what is custody? As far as child support goes. Well, custody, as far as child support goes, with regards to support, is where does the child in question spend the majority of their time? With what parent, or with what other relative? I say that because let's say that grandma and grandpa have primary custody with a child who's with the grandparents instead of mom and dad. Okay, they have a right to file for child support. Say a family member has custody, they have a right to file for child support. Or you have a married couple that are getting divorced. Whoever has primary custody with the divorce proceeding has the right to file for child support. Now, what happens if we have 2 individuals who are not married and have a child in common? What happens? Well, the first thing that has to happen is, number 1, in New York State, the birth mother is considered that child's parent unless the other individual consents on the birth certificate that they are the parent of that child, or there is an order from family court or Supreme Court that sets forth that that individual is the parent. If you do not establish that, the individual who has the child in their possession cannot get child support from another individual. So what I mean by that, mom has a child and she files for child support against another individual, believing that that is the father of the child. That in itself will not get you child support. You have to establish paternity first. You have to file a paternity petition. Now, what is child support? So child support, basically, what you look at is, Vitaly, can we go to child support calculations, please? Thank you. So when you look at child support, I'm sorry, keep going. Child support, what is considered income? Thank you. Okay. So what is considered income? So right now we have 2 individuals, and let's say we have custody established where one of the parties has the child with them primarily more than 50% of the time. Then the court decides, and what you have to look at is what is income? So disability income, I put it to you this way, everything you should consider to be income unless you find that it's not. That's kind of what we look at. So what we look at here, pension benefits, is that income? Yes. Unemployment, social security benefits, yes. Disability benefits, yes. Now, a lot of times I have individuals that say, well, I receive disability payments because of an injury, or I receive disability payments from the military. Okay, now those type of benefits would not be distributed in equal distribution in matrimonial proceeding, but they are considered income because that is money coming in. A lot of people do not know that, but that is income. 1099, W-2s, individuals that are self-employed who would go ahead and write off a lot of expenses. Lots of times we'll have whoever is self-employed come into court and say, well, Your Honor, here's my tax return. Okay, you can see it, and I lost money. So there is no income. Well, then what you have to look at, what the court looks at, well, we understand that. So then we take a look at what did that person write off? Because a lot of the write-offs are going to be considered income, okay? Depreciation, someone writes off depreciation, right? That's income. Someone writes off their car, okay? They write off a portion of their house, their utilities. So you really, if you have a case where you have someone that is self-employed, you really have to know about taxes, about the write-offs, what is being written off, and would that be considered to be income if you go in front of a sport magistrate or a judge? Other types of income. Gifts. I received a gift. My mother gives me $1,000 a month as a gift to me, and I use that. And is that income? Sure it is. Okay. That's money that person is receiving from the outside source. So when you start off, you look at child support. Number one, where does the child reside primarily? Number two, income. Look at all forms of income that the person is receiving. Okay. Secondly, you have the income set, you have the custodial arrangement set. Then the next step is we have an individual that comes into court and they were making, say, $50,000 a year, but they know that child support is going to be issued when they're coming to court. So they quit their job. Okay? Quitting is different than termination. If you're terminated from your job and it's not for cause, what I mean by cause is, say you get caught stealing, you get caught breaking some company rules, and you're terminated for cause because of that, okay, they can still they'll impute your old income to you. If you're terminated because you lost your job because they're downsizing or something of that nature, then the court will most likely not impute income to you. What is imputed income? Imputed income is the judge is sitting there and saying, okay, X, Y, Z, you were a manager of a restaurant, and prior you were making $50,000 a year, and you quit that job. So since you quit that job, we're going to impute income to you of $50,000. And that's what we're going to base your child support off of. Not that you're getting unemployment now. Okay. Now, if the individual got terminated and it was for downsizing, the courts won't do that. The courts will say to this individual, and they'll ask them, are you looking for work? Like how many resumes are you putting out? How many job fairs are you going to? And they're going to really look into that, how hard that person is looking for a job. And they would probably just base the normal child support on unemployment that he's possibly getting now, or a lower paying job by continuing to look for a job that he's capable of doing based upon his past work experience. Now, also, when you look at imputed income, you will have an individual come to court, and that individual would basically say, I haven't been working for like a year. And then they'll say, is anything wrong with you? No. You have a car? Yeah, I can drive. What have you been doing to pay? Well, I'm just kind of sitting home at my mom's house and, playing video games or hanging out, not really looking to work. Well, what the court's going to do at that point in time is going to say, well, Mr. or Mrs. X, there's nothing wrong with you physically or mentally. You can work, you have a vehicle. So we're going to go ahead and we are going to impute income to you based upon what the court normally would do is that minimum wage times a 40-hour work week. And they're going to say, you're capable of doing this. There's plenty of jobs out there where you can go get a job. You just can't sit home. And what the court's going to do is that we're going to impute that income to you, and you're going to pay child support on that income. And they're going to say, I don't care if you make it or not. I don't care if you're working or not. You're going to pay this. And if not, then you're going to be violated. And you possibly also go to jail. So you better start looking for work. So that's kind of how we look at income. So we have custodial issue set. Now we have the income issue set. So then what happens next? And if we go ahead and then let's take a look at calculating your child support. Kelly, can you go to child support calculations? So what we end up doing here is the Child Support Standards Act. So the Child Support Standards Act was established in 1989. And the Child Support Standards Act was set up because prior to the Child Support Standards Act, judges and support magistrates, it was in their discretion how they had standards to look at, but there was no set percentage or anything like that of how they were going to go ahead and determine support. It was in their discretion of how they would go ahead and make someone pay support. So basically what you're having all sorts of different calculations, different amounts for kids. And what happened was that they decided to say, okay, we need to set forth some sort of a calculation. Now, when you look at the calculation, and I'll be the first to tell you, I'm not a fan of the Child Support Standards Act. Okay, I'll discuss why in a little bit, but they came up with 5 different percentages. How they came up with those percentages, I have no idea. I don't think really anybody has an idea. But basically what it says, the Child Support Standards Act, and these percentages have not changed since 1989. It specifically was established child support amounts that allow children to have a appropriate standard of living based on the income of their parents. Now, remember it says for the children to have an appropriate standard of living. It didn't say anything about the person who's paying child support to have an appropriate standard of living. Never said that. So what I mean by that, and I'm just going to give you an example, and a lot of attorneys think the same way about this, is let's just say we have 2 parties, say they're working at Stewart's or somewhere making $15 an hour. Okay, so that's $600 a week. And then what you do is you take that $600 and The primary custodial parent still has that $600. That's gross. Okay. Then we have the individual who has to pay child support. And then his $600, okay? And say there's 2 kids, it is 25%. So the first thing, how do you figure it out? You take the gross income, impute it or whatever it might be, and then you take out FICA, okay? Basic taxes, that's 0.0765. All right, so if you do that, and then that is when you take 25%, figure this out real quick. So we go ahead, $600 times 0.0765 minus $600. So now we're taking child support of $540 times 25%. You take $139 right off the top from the payor income. So then if we take 600 minus 139, now he has $461. Then what you got to do is, of course, then we have to go ahead, and this individual, of course, like everyone else, has to then pay taxes. So then let's just take that 461 and let's just say 20%. So then that paycheck and all the taxes, insurance, and so therefore he has to take roughly another $100 out. Now he has $361. Okay, and then so what you do in a case like this is that the individual who has to pay, if they're this type of an income, you continue to whittle down that individual's income. And the 139 goes to the person who has the kids, which is fine. I mean, he has to help pay for his kids, no question about it. But then again, this Child Support Standards Act, these percentages, when you're looking at income, lots of cases that I have, and lots of the cases that attorneys have in these type of situations, the money gets so whittled down because of what they have to pay, because then they also have to pay under the Child Support Standards Act a portion of health insurance costs. In this case, if he says he's making 600, 50-50. Okay. Then let's just say there's daycare, and he has to pay 50%. Let's say daycare is, I don't know, let's say it's $150 a week. So then we take his 361, and then we take out 75. Now he has about 280 bucks. I'm just going to round things, $280. Okay. So this is also, of course, to support his children, and he does have to support his children. But the situation that you have is that now this gentleman or lady who's paying support has $280 a week. Okay. Or let's just take it 4 weeks. Let's just do that. This individual now is $1,120 a month. Let's do it 4 weeks. Okay. He's supporting his kids. He's a good dad. Okay, he's a great dad. He wants to support his kids. But the situation now he has $1,120 a month to find an apartment, at least with 2 bedrooms, so the kids can have a room. Pay for his car, pay for his gas, pay for his food, pay for his utilities. You know, hopefully be able to buy the kids a Christmas present. There's not enough money there. Okay, it dwindles it down so much where it's almost impossible for individuals on these type of income levels to survive, but they don't care. The courts don't care, right? I've had judges say to me, to my client, Your Honor, my client can't live. And I had a judge say to me, well, Mr. Belsky, have him go pick up bottles on the weekend to make up for it. So crass they get. Okay. We don't care. This is a Child Support Standards Act. Nothing to do about it. Too bad. Then go the other route where, say we have an individual making $100,000 a year, okay? And this guy doesn't do anything with his kids. The kids live with the other individual. That other individual, okay, let's just say is maybe on disability, or maybe doesn't make a lot of money, okay? So this individual making $100,000 a year as one kid, let's just say, so he pays about $1,200 a month to the individual that, you know, not making a lot of money, public disability. And 17,000 doesn't bother him any, okay? Does that money actually support the needs of those kids with the other parent? No, it doesn't, okay? So they're really, these calculations are made out, but they don't take into account all these other issues that occur with current family situations, right? That's the problem that I have and a lot of attorneys have with these support calculations. But this is what we're stuck with, and this is what we have, and this we have to go forward with. All right, so you go to court and you go and you get into court, the judge orders that your client pays X amount of dollars, and there is a child support calculation sheet that goes with this. And then everywhere it goes, what's this statutory cap that I hear about? So what the statutory cap is that New York State every year modifies what they call the statutory cap. So right now, the statutory cap is $183,000 for child support. And so what does that mean? Well, the court says that if two parties, when you put their combined income together, is over that statutory cap of $183,000, we believe that if you have $183,000 in income, that income, when you take these percentages, is more than enough to support a child in New York State. So any money above that cap, let's say each parent makes $250,000 a year, okay, 150,000 a year. That's 150. That's 300. So when you take 300, that's called the spread between the statutory cap and their income. So what the court starts off and says, okay, we're going to make the non-custodial parent pay his proportion of income up to that $183,000 statutory cap. So let's just say, in this case, they both make the same amount of money. So you take 183,000, let's say times 17% for one child, and that'll give you the child support number on $183,000. Then it's going to say, okay, what percentage of the income of the payor is that? 50%. So you would take that number, 17% of 183 times 50%, and that would be the payor's child support obligation. Let's say it goes way different. Say it becomes a 70-20 split. Then when you do the same calculation, the payor would have to pay 70% of that money based upon the statutory cap. And the payee, the person getting the money, their responsibility will be like 30%. So, but then what happens with the money you make that's above that? Then it's in the court's discretion, excuse me, to go ahead and determine should they go above the statutory cap for payments on the income above child support. And there's numerous factors that the court looks at to determine should that go above that cap. I usually see going above the cap, we have such disparities of income. Let's just say, oh, the person receiving child support, their income, let's just say $100,000. The payor's income is, let's say, $400,000. Okay, that's where you would look at in this area. I think the court would look at above the statutory cap to have them pay possibly additional monies to the other party. Okay, and they have a whole list of things that they can take into account in setting forth that additional amount. Now, what you have to remember is that if the court is going to go above that statutory cap, they have to put in detail what the statutory factor they used and why it applied to the case. If they don't do that, then the order is void. Okay, they have to put that in there. They just can't say, well, I'm going to apply the percentage of income above the statutory cap of another $100,000, and this is it. They have to tell why. All right. So we have child support. We have the statutory cap. We know what the percentages are. So then what happens next? All right. So you get this order, and Taylor, can you go back to the child support basics, the first page? All right. So now we have this order in court, and what happened, and one party is supposed to pay the other party a certain amount of money in child support. And so a couple ways that child support can be paid. It can be paid directly from the payor to the payee, the person receiving the money. Okay, but that usually is something that the parties have to agree upon. Or it can be paid through the child support collection unit. Now, New York State has a child support collection unit. And what happens is that at an end of the case, the award is, let's just say, $100 a week. And the individual receiving the money says, I want the money through the child support collection unit. And the other person says, hey, I don't want that because I don't want that, coming out of my pay. I don't want my work to know about it. It shows up kind of embarrassing. Can they fight it? They cannot. You cannot fight it. The other party receiving the money wants it out of the check. They're going to get it out of the check from that person. No ifs, ands, or buts. The same thing, let's say the parties originally in an agreement agreed that the payor would pay the payee, child support through directly. And he's not paying, he's behind, he's late on his payments, she's late on her payments. Okay, all that person that is the payee, they don't have to go back to court. All they have to do is go to the child support collection unit in the county that they're in and say, I now want my child support out of the child support collection unit, and it'll happen. You don't need language in there that says, if you don't pay, you have a right to do it. They have a right to do it whenever they want to. So, and then what happens with the child support collection unit, they will go ahead and they will send information to your employer. They will let the employer know the amount that has to be garnished from your check for child support. Your employer will then start holding this amount of money from your check and sending it to the child support collection unit to be credited against your child support obligation. Normally what's happening now, the payee who is going to get the support, they're usually at this point in time, they're usually giving them cards, pay cards, that they can then go ahead and take their money out, like an ATM machine, or use them if they want to, like a pay card. That's what's normally happening now. They don't send checks anymore to people when this money comes in. So let's just say that, I'm going to take a step back again. The payor in this case is so angry, he goes, then again, okay, fine. I'm quitting my job. You're not getting nothing from me. I'm going to go work at XYZ and make $20 an hour instead of $100,000 a year. So let's all think back. And what is the court going to do when he doesn't start paying his payments like he's supposed to, and the person receiving the money files a violation. I'll talk about a violation in a second. He's going to get to the court, and the judge is going to say, Mr. Belsky, you're not paying your money. And I say, that's right, Judge. I quit my job. I'm working at this other place making, $30,000 a year. So I want, that's why I can't pay it. And he's going to go, well, Mr. Belsky, as you all know, we just spoke about this. Well, I'm going to impute income to you of your $100,000 because you quit your job voluntarily and you can't do that. So you're going to keep paying this amount of money. You're going to keep getting your arrears. And if you don't start paying this, there are options that I'm going to have, I'm going to talk about in a second, could be one of them, could be putting him in jail. Then I look at him and I could say, okay, fine, I don't care, or I better get back to my job or find something where I can make these payments. There. So what happens when you don't make your payments? So you don't make your payments, and the person receiving the money files what's called a violation petition. Okay. The violation petition is basically asking the court, listen, Mike Belsky is not paying his obligation to me, and this is a child support order. He's violating this court order. He's not giving my money. I want him held to the responsibility that was directed at this court would say he has to pay me. So what will happen is that the parties will go into court, and the first thing that would happen, of course, the court's going to say to me, Mr. Belsky, do you want an attorney? And I'm going to say, well, no. And then the court's going to say, well, Mr. Belsky, do you know that one of the things that could happen here is that you could be incarcerated if you do not show why you cannot pay this money? What is the significant change here why you cannot pay this money? Well, at that point in time, Mr. Belsky, myself, I have a right to get a public defender because I could be going to jail, or I have a right to hire an attorney. At that point, you probably would. So next step, we're going to court, and the court's going to say, Mr. Belsky, why can't you do it? Well, I quit. I didn't want to pay that money. Well, that's willful. So there's willful and non-willful violations. What is a willful violation? A willful violation is when you willfully failed to comply with the court order, and you willfully do it when you have the means available to you to pay this money. Let's say you quit your job voluntarily. Let's say you just decided not to pay because you don't want to pay. Okay, so you have the means necessary. You had the means necessary to pay this, and you just did not pay it. And remember, the burden is on the individual when there's a violation petition to show why they could not pay. Okay, what was the reason Mike Belsky could not pay his child support? If I can show there's a reason why I could not pay it, it could still be a violation because you violated the court order by not paying, but it's not going to be willful. It's non-willful. There's no jail or anything associated with that. What they would do, they would set up possibly some sort of a repayment program for the arrears. Me as being the person that couldn't pay it, if I had a certain reason why, I would have to file for a modification of the child support, which I didn't do. I didn't know I could do. And so that could be a non-willful violation. Now, what I mean by non-willful, so I'm making that $100,000, and all of a sudden I get cancer. Can't work. I'm out of work on disability for a long period of time. Okay, and I can prove that I'm disabled. But I am disabled. I can't work that job again. These are type of things that would show that it's non-willful. Okay, I lost my job not because I quit, but we downsized. Those type of things. All those things would give you a basis for non-willful. but it would also give you a basis to modify your current custody, your current support order. So always remember that, and I always tell everybody that if for any reason in support, if there's a change in circumstance, and you're not the person that is just, thumbing their nose at the court, you need to file right away, because any type of a modification for child support commences on the date you file. Doesn't go back. So let's say 6 months ago, I'm on disability, I hurt my back, I can't work, or I'm laid up or something, and I just don't do anything. And the arrears just keep building. The arrears are that if still you're supposed to pay 100, you don't pay. The arrears just keep building. Okay, when I finally do file for a modification, when the other party brings me to court, I can't go back and say, well, geez, Judge, 6 months ago this happened, so now can I get a credit back 6 months? It doesn't work that way. It only gets from the date you file forward. The same thing with child support. I have individuals that come say, geez, I had this child, out of wedlock, he's a father, he signed a birth certificate, it's been a year, if you give this individual, give me a couple bucks here, there, now I stop paying. I want to file, I want to get money all the way back from that year. You can't, it doesn't happen. It's from the date of filing forward. It's always remember that. So if something happens, don't wait, file right away. Modification, violation, child support to get paid to you. So file right away. Now, what else can happen if you don't pay? Well, what happens is that they'll take your tax return. I have clients that call up and say, geez, Mike, my tax return, that's took like $3,000, my federal state tax return. First thing is, well, the old child support, they go, well, yeah, I have arrears, they're going to take it. Okay. And they're going to put that against the arrears for your child support. Other individuals will call up and say, Mike, they just took my driver's license. I can't work. How am I going to drive? And I'm going to say to them, well, the child support, like $5,000 in arrears. Well, they're going to take your driver's license. Now, to me, I think that's a bit drastic because number one, the individual, if he's behind, if he's making some type of an effort to take their driver's license, that's a bit drastic. As a person has to continue to work, try to pay the bills, try to pay some child support. That situation where someone's just thumbing their nose at the court and is behind like $5,000, $10,000, $15,000, sure, take your driver's license. Maybe the guy will come and help support his kids. Okay. I have no sympathy for someone that doesn't want to support their kids if they're trying to do the best they can. All right. So they can also, 1 second. Also, legal fees. If you have a violation and there could be legal fees involved, that party would have to pay for legal fees. Next, I'm going to go into termination of child support and then drafting petitions. Taylor, do you have a code or something you want to do now?
Yeah, before we get into termination of child support, I'm going to read out loud the first course code. It's going to be 970105. Again, that's 970105. And I'll leave that up on the screen for everybody for a moment. All right, we should be good to move on.
Okay. So the next thing I want to talk about is, termination of child support. Now, New York State sets forth, and New York State is different from other states. Some states at 18 for terminating child support as an age. New York State has 21. Okay. So that's where you start off as 21. So as soon as one of the children, let's say we have one child here, the one child turns 21, child support is terminated, okay, automatically. Now, I always tell my clients, file the modified support before the child turns 21, just to make sure that there's no issues regarding termination of child support. Because what happens is that if for some reason you continue to pay these support amounts, you're not going to get them back. Especially if there's a support collection unit. The court's pretty much almost looking at now, it's a gift that you're giving this other individual because you didn't do what you were supposed to do. All right. The same thing in any of these other termination of child support issues. Make sure you file right away. Okay. For instance, we have an individual that, let's just say, is paying child support to the other party. And one of the agreements, one of the things that happened was a change of custody. So we have this parent having custody of the child, this parent having visitation. This parent having visitation is paying child support, let's say $100 a week. The child then moves in with this parent, and there's still a custody order, and that money is still going through support collection, coming out of his check, $100, even though the custody is here. And this client, this parent here says, listen, I don't need this parent's, I don't want this parent's child support. I don't want any of the money. I don't need any child support from this other parent. I just got custody. I'm happy with that. And they keep taking the money out of this guy's paycheck and this person's paycheck. And then, 5 or 6 months down the road, he goes, gee, why should you get that money back? I mean, I don't want him still paying this money. And he goes, calling me up and says, Mike, I want to go and file to get that money back. And because of the change of custody, I tell him, you're not going to get it. Okay. And so we go into court and we file for a modification of child support, and we get the modification to terminate it, but you're not going to get that money back that you paid. The courts have said, that's pretty, you've been giving that other person a gift of extra money. Okay. You're not going to get it back. So this is, again, if there's a modification somewhere, file immediately. You're not going to get the money back. Okay. So then, next thing would be the child goes into the military. The child going into the military automatically terminates child support, because at that point in time, neither party is really taking care of or supporting that child. The federal government now is taking care of that child and supporting that child, because that child's in the military. So therefore, child going into the military, the person is paying child support, files for a modification to terminate it immediately. And I always, so in no way, go ahead and file. Agreement. Now, these two parents, they have a child, and they say, listen, how about if we don't want to pay, either we both agree that I'm not going to pay you child support, and the other party, that's fine. Maybe just help me out with some expenses here. And they're all happy and everything good. 6 months goes by and now they hate each other. And the person who was getting child support says, you owe me like $10,000 because you weren't paying me support under this order. And the person that was paying support said, wait a second, we had an agreement, that we weren't going to pay each other. And, the person who was supposed to get the support goes to court, files a violation. My client comes in and says, well, they had an agreement between them that they weren't going to get support. The court said, oh, too bad. If you have a court order, if you don't modify it, remember, it stands. No matter what they say or people discuss with each other, it stands. Now, by agreement also, let's say we're doing a divorce and both parties agree in the divorce that neither one, even though there's possibly one parent going to pay child support to the other, they both agree that they're not going to pay any support, or the moneyed spouse is supposed to pay $2,000 a month to the non-moneyed spouse where the kids are living, but the parties agree that the moneyed spouse only can pay $1,000. So they come to terms on some number. Now, if you have an agreement, you can deviate from the Child Support Standards Act. The court does allow you to do that, as long as when you deviate from the Child Support Standards Act, you set forth in your agreement what the child support should be, who should be paying it. And then you have to set forth why the parties are going to deviate, specific factors. Okay? Is it because that one party is going to pay additional sums for school? Party agrees that they'll help contribute to clothes for the kids. So the number of deviation factors. So once you put the deviation factors in there, that's binding. Okay? And it continues to be binding until those deviation factors possibly aren't there any longer. What I mean by that is, let's just say we gentlemen divorce and they're paying $1,000 and they have all these deviation factors. And then all of a sudden, these deviation factors are gone. Okay? Let's just say one of the deviation factors, big one, the non-custodial parent agrees to have the kids with him 3 nights a week and pay X, Y, and Z and do certain things. And all of a sudden, the non-custodial parent says, I don't want the kids 3 nights a week. I'll get them like 1 weekend a month, and I'm not going to pay for any of this. Then those deviation factors are now gone. And that individual can then go back to court and say, yes, we did deviate, but now the deviation factors are gone. And I want to change this. That's a modification. To modify. Okay. Other things that you look for modification would be New York State now has specific language where any support order, if there is 3 years since the date of that support order, so let's just say today, and it's a support order made today, for me to pay X to another individual, or a 15% increase or decrease of income, you have a right to go back to court and modify support based upon those issues. So I'm bringing this up because if you have a settlement agreement in a divorce proceeding, you have deviation factors, and these parties stick with these deviation factors, nothing has changed. And we have income here has gone up, but he's still paying this amount of money. Okay. All right. After 3 years automatic, this party gets to go back and modify support. And this comes, or the parties can opt out of that. So if the parties opt out of that and they say in this agreement, we're opting out of that, we're not going to do it, we have to show a substantial change in circumstance of why this should be modified, why the support should be modified. So what New York State basically did was basically threw up this ball and said, okay, every 3 years, you get to look at the child support and see if it's modified. That way you don't have to come back and show any type of change in circumstance, why they need more money, those type of things. So if you're going to do an agreement, be very careful when you look at that language and remind your clients that 3 years, they're going to be able to go back, but you can opt out of it. If both parties agree to opt out of that in an agreement, then you cannot do that. All right. Okay, so real quickly, I know we're running out of time and have a question. So how do you file? We talked about this. So you want to file for support, you go to court, you file for child support. It's very simple. You can hire an attorney to do it. You can find these petitions online. You'll file. You'll have to fill out what's called a financial disclosure affidavit, supply tax returns, pay stubs. The other side has to do the same. And then if you have to go to trial, you can. Violation petitions we spoke about, right? Modification petitions we spoke about briefly to modify support. And those are basically the ones that you normally have for child support. That's what you normally see. I guess there was now time for questions.
If there are any questions, well, before we get to the questions, let me read out the second course code. But if there are any questions in the meantime, please submit them via the chat so I can send them over to Mike. Our second course code is going to be 6944635. Again, that's 694635. And I will wait a moment for any questions. Mike, are you able to receive those via WebEx, or do you need me to read those aloud?
They could read them because, yeah, they could read them to me.
Okay. So the first question is going to be, in your experience, how do courts treat child support in 50-50 custody?
Okay, that's a good question. One of the things I wanted to get to, but I can't tell. Right now, 50-50 custody. There is a case that went back years, and this went up to the appellate court, and the appellate court determined that even if it's 50-50 split custody, the parent was making more money than the other one, is to be considered the non-custodial parent and has to pay the full measure of child support to the other party. Now, that's the most ridiculous thing I've ever heard. Because let's just think it's 50-50. And one person making $55,000 a year and the other person making $50,000 a year. So all of a sudden they have 50-50 custody. Now the person that's making $55,000 is considered a non-custodial parent, and then has to pay, let's say, 25% of his income to the other party under the current case law. That's ridiculous. Okay, and most of the courts realize that. Most of the courts I go into, there's deviation factors the court can use. There's probably about around 12 or 13 of them. Most courts, if it's pushed by the other side, then they use the deviation factors, kind of reel that in, all right? But that's the current case law right now. And all the courts and all the family court judges and support measures are looking at that, all right? But that's still out there, okay? The non-custodial parent is supposed to pay. So, and this also leads to custody issues. Let's just say, okay, let's do 50-50. And one party says, make 60,000, the other say 50. The attorney for the person making 50,000 goes, yeah, we'll do 50-50, but we don't have the full measure of child support. My first comment to them is, number one, are you nuts? And number two, you want to play games? Okay, then if my guy's good enough or girl's good enough to have 50% custody, then we're going to go for full custody, because there's no way we're paying you full child support when the incomes are this close. All right. Now, the next thing what I do also, let's say the same thing. Say we have one party making 50, another party making 100, okay? What I try to reason with the other attorney is that, let's look at the spread. What do you mean by that is one party's making 50, one party's making 100, even up their income at 50, my client's making $50,000 more. Let's take 17% of that 50 to go to you to help you out. Lots of times, that's the way things are working out. That's how, that just, I hope that probably answers your question, but it's still out there. I mean, depends on what judge, you know, where you go, what attorney you get. You have to want to play hardball, but I always go ahead, in that case, and it gets that bad, and you can always seek custody. Go ahead.
Next question is going to be what to do if the agreement provides for child support for 2 children, but one of them gets emancipated.
Yes, very good question. What you do as soon as that child gets emancipated, you have to file for modification child support to lower your child support. If you don't, like I said earlier, and you continue to keep giving the money to the other party, it's gone. You'll never get it back. But I also have to tell my clients also, let's just say we had an agreement from 7 years ago and they're supposed to pay for 2 kids, oh, let's say $300. And right now, my client's income has gone up so much that if he went to file to modify this child support because of 1 child, that old order completely goes away, and they're going to take 17% of his income now. Lots of times, he'd be paying more child support now for 1 child than he was previously for 2, and they don't do anything.
Next question is going to be, how does the court deal with child support when a kid goes away to college?
Well, as far as the child going away for college, it really has, well, this is where it gets beyond the basic child support calculation, child support. But a couple things that if a child goes away to college, what happens is that if there's no language in your agreement, okay, that says anything about college. So let's just say then, and then the question becomes, are you helping to pay for college? Let's just say the child goes away to college, comes back to the custodial parent, and let's just say, are you paying anything to help for that college? If the answer is no, then you're not going to get anywhere. You're still going to pay the amount. But if you agreed that you're going to pay, say, 50% of the college tuition, which includes room and board, okay, food, then what you could do is you can back to the court and say, well, Your Honor, you know, I've agreed and I'm paying, you know, 50% of the room, the board, okay, and food. And that kind of is the same thing you look at, because your child support is for basically, you know, food, keeping clothing, keeping a roof over their head. But if the child's away to college and you're paying that and you're paying the same in child support, then you argue that you should have a decrease in your support because the other party didn't double dip.
And then our final question is going to be, is it a 15% change in income or every 3 years? Can parties agree to waive or change either of those?
It's either 3 years, or you could do either or. So it could be a 15% increase or decrease in income, or it could be 3 years. So let's say that I'm paying child support and I'm making $50,000 a year. And all of a sudden, a year from now, I get this brand new job making $150,000 a year. That's more than a 15% increase. And the person I'm paying support to knows that. They can go back and they can ask to go ahead and have the child support modified. But you can waive that issue. So you can waive it. So if you waive it, you can't go back after the 3 years because that's that 3 years or just the 15%.
And then just one last question just came in. What is the significance of deviating from the Support Standards Acts in an agreement for future modification?
What's the difference between deviating in an agreement?
No, what is the significance of deviating from the Support Standards Acts in an agreement? And then question mark for future modification.
Well, the significance is that you're hopefully, if you're the one paying child support, the significance is hopefully that you're paying less, okay, based upon an agreement. The deviation, well, you're not going to deviate where you're going to agree to pay more than you should. So I've never had that happen, okay? But it does happen. So you're hopefully getting a reduction in your child support with the deviation. And then as far as the deviation goes, when you move to modify that, okay, and say you waive the 3 years and the 15%, and you have this deviation where you're paying less than you're supposed to, and all the deviation factors are still in place, the other party just can't go back and say, hey, my kids are growing up, now they need more stuff, they need fancy sneakers and phones and car insurance and all that, I want more money. It doesn't work.
And then the last question that just came in, can parties entirely waive child support?
I'm sorry, what was that?
Can parties entirely waive child support?
Okay, well, no, what if you can't? You cannot waive, well, you can waive support. But what has to happen? Well, number one, you cannot basically give up your child and say, I'll give my child, I'm going to give up my child, I'm going to waive support. You're obligated to support your child until the child's 21. So let's just say we have two parties and they say, listen, I don't want any support from you, I don't want any support from you. So what you have to do in that situation, you have to go ahead and you put in there, again, why you're waiving support from each other, and then the deviation factors why, okay? That's what you do. Now, or if you're talking about, I want to give up all my rights to mom, and I don't want to pay any child support, okay? Well, you can't give up your parental rights and just walk away from support. The only way that can happen is if the child's adopted, okay? But what I have parties do in that situation would be, say, I would say dad. Dad walks away from the child and says, I never want to see the child again. I don't care, never want to see the child again. Mom says, well, that's okay, then I'll agree not to pay if you don't pay me child support. But then you have to put a provision in there that says, if for some reason dad wants to now see the kid again or try to get back into his child's life, mom has a right to go ahead and seek child support. The same thing. If mom seeks child support, the father then has a right to file to get back in the child's life. But that's the only way you can do it. Hope that answers the question.
Those are all of our pre-submitted questions.
I'm sorry, Bill?
Those are all of the submitted questions.
Okay, thank you, everyone. If you ever have any questions, please, you have my email. Give me a call if you have a quick question. Be more than happy to talk to you. If you have cases, if you need representation, call us up and we'll be more than happy to get you in for a consult. Thank you, everybody.
Yeah, thank you everyone again for joining today's presentation, and thank you, Michael, for presenting. Please ensure that you complete and return your course evaluation and affirmation to CLE@tullylegal.com within 2 weeks to receive your certificate of attendance. Thank you, and I hope everyone has a good rest of their day.